Good afternoon, everybody. My name is Maryvel Valdes. Thank you for joining me with this discussion on collection strategies for associations. I am one of the collections attorneys here at the firm, and I have extensive knowledge on the collection practices, and I feel this is an important topic. To begin with, collections is a very sensitive subject for many board members. The reason being is because they don't understand how the process works for the collection of unpaid assessments. So we'll review the statutes and then we'll move forward with what can be done. To begin with, Florida statutes 718 and 720, the Condominium Act and the Homeowners Association Act provide that a unit owner, regardless of whether they've taken title in a regular transaction or by foreclosure, are responsible for the payment of assessments from the moment that they take title. And once they take title to the property, the declaration will provide the method, the manner in which assessments are adopted and the method in which they are collected and when they are due. So typically you'll find that in a declaration of condominium or a declaration of covenants, there will be a paragraph that discusses assessments are due on a monthly basis or on a quarterly basis. They're due on the first day of the month. They may state whether or not late fees may be charged if a payment isn't made by a particular date, and they will or may not include whether interest will be charged at the default interest rate, which is the highest rate allowable by law. At this time, it's 18%, or whether there is a 15% or a 12%. Again, that would be something that would be included in the declaration under the assessments paragraph. But if it doesn't include it, the statute allows that it be 18%. Now, it's important to note that assessments are the association's main source of income. So for the purposes of paying for those items that would assist the association in running the day-to-day operations of the association, they have to collect certain amounts, and those amounts are budgeted for typically on a yearly basis. And then that amount is provided to the membership, and the membership then goes forward and provides that budget to the members so that the members are aware of the amounts that would be collected on a monthly or quarterly basis, depending on the association. And those are the obligations that the association has to enforce against each one of the owners. Now, for certain associations, if they do not have in their covenants a provision that says that they have the ability to collect late charges, if they are not included, the statute only permits late charges to be included if the covenants allow you to collect them. So one of the important things to look at is, do you have this ability to do this? You shouldn't be collecting late charges if your declaration doesn't allow you to collect late charges. And to the extent that it's definable, whether it's $25 per month, or if it's an amount to be determined, or if it's 5%, take a look at what the governing documents state in order to determine how much may be charged and if it's being properly charged. Another item to look at is the interest. Is the association collecting interest on the amounts that are outstanding? If it's not, will those be collected by the moment that it is sent over to a collection agency or an attorney to collect? So those are little things that one should be looking at when you're looking at the amounts that have to be collected from a delinquent owner. Now let's get into the nitty-gritty. When an owner has become delinquent in the payment of assessments, and I'm just going to say John Smith lives in a condominium unit, and in his condominium, he's required to pay $100 a month. He hasn't paid his assessment for 2 months, and the board is interested in finding out, well, what can we do at this point? So the statutes recently require that in order for an association to be able to collect unpaid assessments and attorney's fees and costs, that the association must send to the delinquent owner a notice of late assessment. The notice of late assessment requires the association to mail to the owner a notice that includes the amounts that are outstanding and provides 30 days for that unit owner to make payment to the association. If the unit owner doesn't make payment within the 30 days, after having been mailed the notice from the association, then at that point, after the expiration of the 30 days, the association may then forward a notice of late assessment together with a ledger to the collection attorney, to the collections agency to begin the collection process. If the notice of late assessment isn't mailed to the owner, then the owner will have an argument that they would not be responsible for the payment of attorney's fees and costs that are incurred by the association to collect the unpaid assessments. So it's imperative that an association understand, without that notice of late assessment being mailed by the association to the delinquent owner, providing the 30 days notice would cause there a argument to be able to collect the unpaid attorney's fees and costs, and those would be borne by the association. So if we get past the point where John Smith hasn't made his first two payments and the association has sent John Smith a notice of late assessment and the 30 days have expired, then the next step would be for the collection attorney or the collection agency to send the initial statutorily required letter, which is, we call the demand letter, but it's a notice of intent to file a claim of lien. The notice of intent to file a claim of lien provides the owner notice that they have 45 days to make payment, and it breaks down the amounts that are due to the association. This will include assessments, interest, late charges, attorney's fees and costs that have been incurred by the association. This notice of late assessment must be mailed to the owner at the address that has been provided to the association by the owner at any given moment. If there is a change in the address from the unit owner to management or to the association, the manager must have that in writing so that they have backup to, in the event that there is a dispute as to why a mail was sent to a particular address, they have the information in their system that would allow them to confirm that the address provided by the delinquent owner was the last address on file. When the 45-day demand letter or the notice of intent to foreclose a claim of lien is sent to a unit owner, the unit owner has 45 days to make payment. If the 45 days lapse, then the next step would be for the association to send the second statutory letter, which is the delinquent assessment letter. The delinquent assessment letter notifies the delinquent owner that the association has or will record a claim of lien and will provide another 45 days for the delinquent owner to make payment. If we go back and we discuss the notice of late assessment and the 45 days for the notice of intent to file a claim of lien, take into consideration that there's been a significant amount of time since the owner hasn't made a payment. So if the owner, John Smith, hadn't made 2 monthly payments at $100, the third month would be when the association has sent out their notice of late assessment. 3 months have passed, an initial demand letter, or what we call the notice of intent to file a claim of lien, another 45 days. By the time that a lien may be recorded against the property, a significant amount of time has gone by. So the reason I point this out is because there are certain associations who have not updated their collections policies. Collection policies should be reviewed on a year-to-year basis to confirm that they appropriately take into consideration the amount of time that has to take place between the notice of late assessment, the notice of intent to file a claim of lien, and then now the delinquent assessment letter. So if there is a collection policy that would obligate the association to first notify the owner or give them a reminder letter, then they should be reviewed by the board, by management, to make sure that not so much time goes by before you're able to move forward with the foreclosure of a claim of lien. Since these changes to the statute with the requirement of the notice of late assessment, the notice of intent to file a claim of lien, which is 45 days, and then the delinquent assessment letter, which allows the association to record the claim of lien and provide another 45 days, we're talking almost 4 months before this can get to a foreclosure process. Another important thing about the collection policy is that you want to notify the owners as quickly as possible if there's a change to the pre-existing collection policy, so that there is no dispute as to why things have changed. So if your collection policy, or if you need to review and make changes, then there should be a board meeting, there should be a discussion, there should be a new policy put into place. And once that policy is reviewed, approved, adopted, then that collection policy should be distributed to all the membership, so that the membership is aware of what the association intends to do going forward. Another discussion that I like to have is with reference to tenants. In certain circumstances, and the statute would allow for associations to collect unpaid assessments for rental from a unit owner who has not paid their assessments. Florida statutes state that in the event that an account is delinquent, if the unit is rented, the association may make demand upon the tenant to collect the unpaid assessments, and until such time as the account is brought current. Keep in mind that the statute, if the statute would allow it, however, we recommend that you review your declaration to confirm that your declaration would allow you to incorporate the new statutory language. And when I say new, I would say 2014, which I believe is when there was the change, to allow the associations to now have this right to make a claim upon the tenant for those unpaid assessments. Notice has to be provided to the owner and to the tenant of the association's intent to make a demand for those rental income, and to make sure that it is paid. Now, the tenant is protected if the tenant makes payment to the association. The statute allows for the tenant to be without fault or liability to the landlord, because they are complying with the statutory requirement and the letter that has been provided to them. With that in mind, and with the claim of lien procedure, I'd like to just touch on the subject of the delinquent assessment letter, which was the second statutory notice that I had started discussing. That second statutory notice, the delinquent assessment letter, provides that the association is going to record the claim of lien and is going to give the owner 45 days to pay. If the owner does not make those payments after the 45 days, the association does have a right to file a claim of lien foreclosure action to foreclose its interest in the particular unit. So if the association chooses to file a foreclosure action, it may do so. If it chooses to collect rents, it may do so. But in the event that it is a claim of lien for a condominium association, the claim of lien would expire after 1 year. And in the event the association does not take action before the expiration of the 1 year period, the association would have to begin the process all over again. If it's with a homeowners association, there's a 5-year statute of limitation that would not allow the association to move forward with the filing of a foreclosure claim of lien action if the lien is more than 5 years old. Now, another topic of discussion with reference to collections has to do with whether the association has the right to suspend a delinquent owner's right to access its facilities, and also whether or not the association may move forward with the suspension of voters' rights. Those you should discuss with your attorney or with counsel to confirm the method in which you must notify a delinquent owner of the association's intent to suspend the use rights if the delinquent amount or any monetary obligations remain outstanding after having been provided notice. And the same goes for voting rights. When there is a delinquency in an account, please discuss with your counsel or your legal counsel to confirm that you may suspend a unit owner from voting if the account is delinquent, and also to determine the date in which they may be considered delinquent, whether they're due on the 1st, whether they were paid on the 1st, and to make sure that there's no other gray areas that an owner may come and argue that they did have the right to vote at a particular meeting, to become eligible to be a member of the board of directors if they are running for election, and also for the use of the amenities in the event that there's a payment made and when it's made. Outside of those particular topics, those are the main questions that we are asked with reference to how to collect from a delinquent owner, how to obtain amounts from a current tenant with a delinquent owner. If there's any other questions, please feel free to reach out to me, to the firm. We're more than happy to answer your questions. But thank you so much for taking the time to listen to this presentation, and we hope you have a good afternoon.